Welcome back, everyone. If everyone doesn't mind, please go ahead and have a seat. If you have a chair open next to you, generously raise your hand so that those who do not have one can find you. We will get started with our next session very shortly. For those joining us online, do not forget to fill out your CLE forms. The form is in the chat. Our next session is a fireside chat with the Honorable Collins J. Seitz Jr., Chief Justice of the Supreme Court of Delaware. Please join me in welcoming to the stage Adam Badawi, Professor of Law at UC Berkeley School of Law, as well as Mary Eaton, Partner and Co-Head of Securities and Shareholder Litigation at Freshfields.
Good afternoon, everyone. It is our great pleasure to introduce to you the Chief Justice of the Supreme Court of Delaware, Collins J. Seitz Jr. The judge was sworn in as Chief Justice in November 2019, which is great timing. If you think about it, meant he shepherded the court through all the trials and tribulations of COVID, and did a fantastic job on that. Thank you. Before that, he had served on the Supreme Court since 2015, and before that, he had been in private practice in Delaware for
long time.
A very long time, some 30 years or thereabouts. I had heard through the grapevine that he is a Swiftie, but, and I tried to pin him down over that at lunchtime, but like any great jurist, he would neither admit nor deny that rumor. So welcome, Judge, and thank you very much for coming. So there's been lots happening in Delaware recently, lots of new and interesting cases and new cases on the horizon, some other interesting developments with respect to whether Delaware, typically the preferred forum for corporate organization, still holds that post, so to speak. So we have many more things to talk about than time allows. So we're going to free flow it here. Whatever suits your fancy, Judge. But I thought we'd kick it off with the Match.com decision, given that it is such a recent opinion to come out of the court. I will tee it up and then pass it over to my colleague Adam, who will ask a couple of questions about that case. So just to level set for everyone, the business judgment rule is the presumptive standard in most cases. In circumstances where there is a conflicted controller transaction, however, the standard is different. The standard is entire fairness. In a case I'm sure we all know called MFW, it provided a mechanism for defendants to basically reinvigorate the business judgment rule where they could meet there's 6 requirements, but among them is a fully independent committee to negotiate the transaction and the vote of a fully informed minority. That case, MFW, dealt with squeeze-out mergers, and there had been some debate for some time as to whether it applied to other sorts of transactions, and Match resolved that question, essentially holding that it applied in all sorts of conflicted controller transactions, and we'll get into the details of that momentarily, I hope.
So there had been some discussion in Delaware, Chief Justice, of so-called MFW creep, right? The notion, which sounds sort of pejorative and may be pejorative, as a way of saying kind of this should be cabined, perhaps. And European opinion chose not to go that way, not taking on the logic that some of the proponents of that had advocated of abandoning this notion of inherent coercion. So could you maybe talk us through how you and the rest of the court thought through those issues?
Sure. Anything going on in Delaware these days? So we have a lot of really big cases right now. It's a great time to be a judge in Delaware because the cases are absolutely fascinating. They're really some of the cutting edge issues that confront M&A lawyers and the plaintiff's bar and the defense bar. Everybody's got their eye on Delaware. So I'm looking forward to talking about Nevada and Texas too. That'll be a fun conversation. But so let's talk about match and MFW expansion or creep. I think it's a misnomer because the premise of MFW creep. So here's the issue, just to frame it. The question in match was whether MFW, the structure of MFW, which allows you to get business judgment review in a transaction that would be normally subject to entire fairness review or most difficult standard review. The question was whether that was limited to freeze-out transactions and that the law beforehand was that an independent committee by itself could bless a controlling stockholder conflicted transaction. And so there was an article written and it coined the term MFW creep. And what that really means was MFW meant to apply to transactions other than freeze-out transactions. And we answered that question. We said, yes, MFW can apply, and a controlling shareholder can invoke MFW to reduce the standard of review from entire fairness to business judgment review in all transactions, not just freeze-out transactions. And the reason that we came, well, the way the argument was teed up on appeal was that the law beforehand had always been that a special committee, for instance, was enough to get business judgment review. And if you look at the opinion, there were 6 Supreme Court decisions that said that wasn't the case. So we talk a lot about stability of the law and hewing to precedent and making sure that we don't turn things upside down in our corporate law decisions. And at least in my view of the world, this isn't a question of creep. The established law beforehand was that entire fairness applied to transactions and not just exclusively to freeze-out transactions. So in my view, we applied existing precedent to the facts of that case and came out and said exactly what our earlier precedent said, and that is you can use MFW in all transactions, just not in freeze-out transactions, but you're still going to be subject to entire fairness if you don't apply MFW in all controlling stockholder conflicted transactions where this controlling stockholder receives a non-ratable benefit.
It's interesting that you discuss predictability because there's been some discussion that transactional lawyers were actually trying to push the envelope by doing something that was not that predictable. But I think it's fair to say you've certainly given them predictability.
I think that's right. And our precedent was very clear on this point, and there's nothing wrong with advocating for a change, but no one asked us in match to overrule that existing precedent. So again, stability in the law depends upon judges applying precedent as it exists. If the arguments come before us to overrule that precedent, we need to consider that, and obviously it's a big deal when we overrule cases, but in my view, predictability of the law is really important, stability of the law, and that means applying precedent faithfully.
So in that particular case, Your Honor, the court found that the special committee, the separation committee, was not fully independent, and as I understand it, the reason for that was that it was comprised of 3 members. 2 of them were independent, but 1 of them was not. The third being susceptible to the influence of the controller. That came, I think, as a surprise to some people who believed that as long as a majority of a special committee met the requirements, that was sufficient. Could you elaborate a bit on the reasoning behind the requirement that the special committee, whatever it's called, separation committee, transactional committee, must be 100% independent for MFW to apply?
It's a really good question, and you know, I think we were intellectually honest in the opinion about there is some tension in our law about when a committee has to be fully independent, how that interacts with demand versus MFW and other factors. The logic is this, at least this is how we explain it in the opinion, that for purposes of evaluating demand, that is a board delegation of authority under Section 141 of the Delaware Corporate Law, which says the board is in charge of the business and affairs of the corporation, which includes evaluating litigation demands. In MFW, that is a separate question. You're not talking about evaluating a litigation demand, and you're talking about replicating arm's length bargaining so that stockholders can be sure that there has been a fair process that reduces the standard of review to business judgment from entire fairness. Now, how do you get that? Well, to replicate arm's length bargaining, our logic was the committee needs to be fully independent. We actually had an earlier case that talked about a fully independent board in this, or committee in this instance, and it was our view that the arm's length negotiator situation is completely different than when a committee of the board is evaluating whether to pursue a claim against someone. So that's basically our logic.
So with respect to that makes sense, Your Honor, but with respect to the demand requirement, I mean, there are some transactional claims, for instance, that are brought as derivative claims. And so in the first instance, the shareholder would not be able to bring that suit without either making a pre-suit demand or adequately pleading that demand would be futile. And if the latter, their obligation is to plead facts that a majority of the board lacked independence or was insufficiently dispassionate to objectively review a demand. So how does this work in a transactional setting then? It seems like there's one standard when it's a derivative case and somewhat of a different standard where the claims are direct.
Well, it's a function of a case that goes back to named Aronson, where and in Zuckerberg, where we recently evaluated the test for demand excusal. And it's really, it's a question of how the claim is going to be evaluated and who is best able to evaluate the claim. So in the demand context, we have said that even though members of the committee may have been involved in the decision, that is not going to disqualify them from evaluating the demand. So what we're trying to do is stick to our existing precedent, although I think you've put your finger on something that is a bit of an inconsistency in our law, but for now we've decided that we're going to live with that inconsistency.
So just one follow-up on that. Is the standard for independence the same? In the demand context, we usually think about it as, well, is this director beholden to the controller? Whereas the independence question, at least in Match, is framed somewhat differently.
I don't think we've directly answered that question, but I think certainly the precedent in our the demand context would be applicable in the MFW context.
That's very helpful, thanks.
Well, first I have to add, I edit a casebook on business associations, and our summer is fairly ruined at this point, given all the opinions.
Sorry to hear that.
It's all right. Yeah, well, it's the least of your concerns. So a case that I teach is Solar Cities, or at least I taught the lower court a decision, which was involved Tesla's acquisition of Solar Cities, which was a controlling shareholder transaction. It was not one where they used MFW to get the business judgment standard of review. It was one where they had to try the issue of entire fairness, and after a long trial, it was determined that the price paid in the process was ultimately entirely fair, and the Delaware Supreme Court affirmed that. I'm wondering what the thought process that the court went through in thinking about that, and what you think it means for practitioners out there who need to think about what to do and what it might mean to be subject to entire fairness.
So I think that the takeaway from Solar City case is that you can win an entire fairness case as a defendant. That was a case that had some bad procedural facts in it on how the process was undertaken. But eventually, looking at both the process and the price as from a holistic point of view, we decided that it met the entire fairness standard. And I think some of the members of the Court of Chancery have also commented that entire fairness is not a death sentence to a defendant in a case. You can try an entire fairness case and win.
If you're paying the legal bills, you might think of entire fairness, perhaps not as a death sentence, but as a burden. But I believe you were saying at lunch today, and there's a suggestion of this in Match.com, that you might even be able to win an entire fairness case at the pleading stage.
I think that's right. One thing that we're particularly sensitive to is frivolous stockholder litigation, and I think we had discussed Trulia before, where there were disclosure settlements that were basically hold-up cases. And we have our eye always on making sure that that the courts are not used as a resource for seeking rent from companies for frivolous claims. So I think one of the things that it's going to evolve after the Match opinion is how the Court of Chancery might frame its evaluation of entire fairness cases such that if they are frivolous, that they might be dismissed at the pleading stage. So it's something that we always have our eye on. Want to make sure that the litigation that's brought before the court is real litigation and not as just putting money in someone else's pockets.
As a follow-up to that, Your Honor, do you have in mind whether a plaintiff has adequately met the pleading requirements in terms of sufficient facts to show that there was a controller, that the controller entered into a conflicted transaction with the company, and as a result of that, obtained a non-ratable benefit?
Yeah, I think those are the fundamental elements that will need to be pled. And I think as the case law evolves following the Match decision, there'll probably be some development around what it means to stand on both sides of the transaction and what it means to receive a non-ratable benefit. So I'll be looking forward to the next cases that come along that start filling in, because I think that's the beauty of Delaware law is we try to be incremental in our approach and not just drop a bomb on existing precedent. And at least it's my hope that the Match decision is received that way. I know some commentators were disappointed that we didn't make a dramatic statement about what the test is for a controlling stockholder and some other things that people wanted answers for. But at least in my view, my conservative view of being a judge, is you decide only what's necessary and you leave for a later day in fuller development some of these other important issues.
One of those issues, one of my favorite issues at least, is the non-ratable benefit issue. So I take it you're saying there may be some scope for pleading stage dismissal motions where perhaps, for example, the controller received some benefit that was not to the detriment of the minority. for
I think we
instance.
already have a case that says that. I think that may already be established in our law, that just because the controller receives a benefit does not mean that something untoward has happened. There has to be more than just the controller receiving a benefit.
So, and just while we're on the topic related to that, even in a circumstance where the plaintiff has pled entire fairness in their complaint, once you proceed to discovery and trial, it seems to me that that is not necessarily the standard that applies, right? You could still show, in theory at least at trial, that it shouldn't apply.
Well, I think the only rub with that is I think we have a decision that says that the issue of a shifting burden or the standard review needs to be resolved before the trial. So again, I mean, these things are going to have to get worked out with the Court of Chancery, but I trust them to figure it out.
I wonder if we can kind of take a step back and talk about some bigger picture issues. When I think of Delaware law, I think of it as being quite responsive to the various stakeholders in the corporation. There's been some cases that have provoked a potential legislative response, perhaps too quick of a legislative response. We also saw Tesla filing its proxy statement this morning, which seeks to leave Delaware, perhaps suggesting that they don't think it's responsive enough. So it almost seems like Delaware's between a rock and a hard place with respect to trying to find the right amount of responsiveness. Right? What is the right amount of responsiveness?
Well, first of all, I mean, it's really great being a judge, but it's really hard being a judge because, you know, as a judge, the most important thing is being independent, and somebody's going to be unhappy usually when you make a decision. You rarely make everybody happy when you make a decision. And so, you know, there's always a lot of tension. Some of the cases that are progressing through the system right now, they haven't been appealed yet. So I wouldn't want to comment on those specific cases. But the important point is there are legislative solutions to some of these. I think in a couple of the cases, the vice chancellor and the chancellor even said that some of these things would be susceptible to legislative fixes. And, you know, again, I just get back to, you know, as a judge, you know, it's our duty to come to a set of facts and apply the law and be independent and not be sticking our finger up, seeing which way the wind is blowing in a given time period, because then the legal system will lack all credibility if we're just going to be susceptible to who we're disappointing or who's winning and who's losing.
Do you think the Supreme Court should get a crack at some of these issues before the lower court opinions are overruled?
I think some of them that they should be subject to appeal. I think you know, we're obviously taking you know, watching these cases, and again, that's why I said this is the greatest job in the world, because some of these issues are just fascinating that are being decided by the Court of Chancery right now. I'm sure the people in the audience are losing a lot of hair. They're pulling their hair out over some of them. But I can just tell you, I know the judges are doing their best job that they can to be independent and bring their best judgment. And you know, one of the unfortunate things about today's environment is people tend to mix up the judge with the decision, and I think that's unfortunate. And I really try to stress to people, it's okay to disagree with the court's decision, but it's not okay to be disagreeable with the judge. You know, let's get back to the time when we could have a civil debate about whether the decision was right or wrong, whether it's, you know, good for corporate America, bad for corporate America. But let's stop attacking the judges who make these decisions. And it's really unfortunate. You know, we feel that in Delaware right now with some of the litigants. And It's my hope that members of the bar, when they see that happen, will come to the defense of judges and make sure that people understand that the judges are doing the best they can, and it's not about the individual judge, it's about the court's decision.
How important is predictability, Your Honor? So, for example, there have been some recent cases where there was a fairly well-established market practice, and that did not carry the day, which says something about predictability. How does the court take into account those practices and people's expectations
Well, I think
around
that's
them?
where the legislative piece comes in here. You know, I've heard that expression a lot, that the court is out of step with market practice. Well, I mean, the court is applying the law, and I'm not making any comment on any particular decision. And it may be that there needs to be a recalibration, either legislatively by changing the law. But again, I think from my point of view, the judge is there to apply the law, and maybe there needs to be a recalibration once in a while when we say market practice is different than the law. And I think that's going on here a little bit right now. It's not the first time in Delaware history that this kind of controversy has arisen, and I could just tell you that in the long run, Delaware has always persevered. You know, there's over 2 million business entities incorporated in Delaware right now. The Court of Chancery is the busiest that it's been in its history. Supreme Court, the number of corporate cases is the busiest it's been in its history. So we're doing fine. We're doing fine. And people are coming to Delaware because of the quality of our judiciary.
That relates to a question I was going to ask, because you mentioned Texas and Nevada earlier. Kind of, it seems like every generation or so, right? Kind of this corporate competition comes up, and this discussion is live again. But as you said, Delaware perseveres. I think you may have previewed the answer to what I'm about to ask. But why is it that Delaware, every time someone tries to challenge them, and Nevada tries to do it by saying, "Come be a controller here," or Texas is kind of saying, "What do you want? We'll give it to you." It has not yet opened the floodgates, and I doubt that it will. Why is that?
Well, I don't want to run down any other state. They make their choice about how they create their courts and enact their laws. I think what has allowed Delaware to retain its dominance is a century of corporate law decisions, a very careful judicial nominating process where judges are nominated and confirmed on the merits. We don't elect judges in Delaware. We appoint them. There are no jury trials, and Delaware corporate law is broadly enabling, which means that there's a lot of flexibility that fiduciaries can have under Delaware law, subject, of course, to compliance with fiduciary duties. So I think for many years that's been the secret sauce in Delaware. It still is, and I think it will continue to be. Texas and Nevada, they're going to do what they're going to do. I don't know if people realize that in Israel, they have modeled their corporate law after the Delaware Code, and they are on top of every decision coming out of the Delaware Court of Chancery and the Delaware Supreme Court. Taiwan has set up a business court. We have almost a sister relationship with Taiwan, where we go over and consult with them on setting up their business courts. They're trying to emulate Delaware. Sometimes I feel like an ambassador. I go to other countries, of Egypt, other countries where they're trying to emulate the secret sauce of Delaware in these other countries abroad. So we really are the preeminent business court of the world in many ways. And you can see that by not just states trying to copy it, but other countries as well.
There are some other important decisions that came out recently, and a couple of others that are on the horizon before the court to be resolved in the relatively near future. Not to make the whole discussion about MFW, but let's talk about the Brookfield case for a moment. So, in Match, it failed because the committee wasn't entirely independent, but it was a different result in Brookfield. Brookfield concerned whether the disclosures were full, such that the minority shareholders had the proper information to exercise their franchise. What happened there? Do you think it's common? Do you think it's easily rectifiable?
Well, I think there were two issues that occurred there, and the first was the banker who had an undisclosed $500 million investment that bore in one of the parties, and the law firm that represented the committee had a concurrent representation going on. So, we don't lightly overturn disclosure decisions by the Court of Chancery, but in this one, it was just so stark to us that these conflicts were not disclosed in the proxy that we couldn't let it pass. I think the lesson from the Brookfield case and the lesson from our other disclosure cases is if you're going to be on a committee and you're going to hire advisors or you're the lawyer representing the committee, the very first thing you need to do is vet conflicts. And I think at least at the pleading stage of this case, it was pretty clear that the committee had not vetted conflicts with its advisors. And that was unfortunate because then you're behind and it's hard to overcome that. And if you just disclose these conflicts and it's in the proxy, I mean, then it's there for everybody to see. But if you don't take that initial step, and if you're a lawyer advising a committee, you don't disclose your own conflicts and also make sure that any other conflicts are vetted, you're going to be behind the eight ball if there's going to be litigation over the deal and if you want MFW to apply. So unfortunately, in that case, because of the lack of informed disclosure, the stockholder vote of the minority stockholder vote was invalid, and therefore MFW did not apply.
There was also a claim in that case against the special committee for failing to look into those matters, a claim that was ultimately abandoned. But you had said that the disclosure issue was a close call. That's what the decision says, on the assumption that the breach of fiduciary duty claim would go forward. Would you put that in the same category? Would that be a close call too, or something else?
Well, whenever judges use close call opinions, that's kind of a signal that we just wrestled with it a lot because it's a big deal to overturn a transaction where so much time has been put into it. But as far as the duty of care, that was abandoned, and that was more of a question of whether the committee had satisfied its duty of care by not vetting conflicts. And I think what the point of the Brookfield decision is the court might have gotten that tangled up with the question of whether there had been adequate disclosure versus whether there was a duty of care violation. So we said the two things are separate, and we did not have to resolve the duty of care question because it had been abandoned.
We have less than 2 minutes left. Unbelievable. And still lots to talk about. You want to talk about
Should we
class
talk about what's
voting?
coming up? I mean,
Let's do what's coming up.
Yeah,
that sounds
so-
good to me.
So we just had oral argument in a case called Kellner, which is an advance notice bylaw case. I'm sure everybody will be watching that very closely. So we'll have a decision out on that in the next few months. And I'm sure a number of these cases that are percolating in the Court of Chancery are going to be appealed to our court. So lots of big decisions will be coming your way from our court.
And what about Dell Technologies? Of special interest to us litigators and for clients who settle matters. Just in brief, that was a case that was settled a short while before trial for $1 billion in cash, which according to the trial court judge was the largest recovery ever obtained by a representative plaintiff. And the issue there was how much to award the plaintiff's firm in terms of attorney's fees, ultimately settling on an award of just over $266 million, which is somewhat eye-popping, including for those of us who settle a lot of cases in other courts. Can't pretend to summarize that lengthy decision in its own regression analyses, but that one is up before the Supreme Court as well. What should we be expecting, if you can comment at all?
Well, I really can't. I can't
regard?
comment on it, but I mean, it does raise an issue, and just to take what the trial court, the Court of Chancery's opinion, you know, there is a question of whether you apply federal securities law, whether we should change our view of attorney's fees and apply a securities law model, which would be a declining percentage as the award gets larger, or make other changes to our attorney's fees evaluation. So we'll be taking a look at that case, and I'm sure that'll be of interest to the bar too.
And I'm sure it will be. I see we're basically out of time. I want to thank you, Your Honor, for your time and your insights and your perspective on all of these important issues. We really appreciate it.
Thank you very much for having me. I appreciate it.